Good morning. Good morning. Good morning. Hello, everybody. Good morning. Good morning. Oh, my goodness. My goodness. Yes, thank you so much, Tish. I appreciate that. Thank you so much. Yeah, I've had to be a little extra careful. I had a vocal injury in college, and so sometimes it can get aggravated if I don't take care of myself. So I need to remember to take care of myself. Do you remember that? Yes, it's back. It's a bit gravelly though, so forgive me. I apologize. But I have some lozenges. I have some really good tea, some throat coat tea, so I should be okay. I should be okay as long as I, don't go for too long. But welcome, welcome. A novel landmark issue. Well, I do have my DMs open on TikTok, so you can send me a DM if you'd like to take a look at it. Oh, well, thank you, Philly. Yeah, good morning. Good morning, Pink Cow. Oh my gosh, Pink Cow, best name ever. Yeah, everything's getting appealed. Everything's getting appealed for sure. We're going to have so many appeals. We're going to get, it's going to be raining appeals for a while. Oh my gosh. So, how does everything get to the Supreme Court? Great question. Usually, how it works, and here we go. Let me get out my little notepad, my learning notepad, right? Here we go. Usually, how everything works is that you have a case, and it's in district court. And this is where the evidence is presented. So you have a trial, evidence, it's argued out. And while you're getting your trial together, there can be issues that come up. So mid-trial, if you have issues, so legal issues, legal questions, maybe there's a ruling on something and you don't think the judge ruled correctly, then what you can do is something called an interlocutory appeal. Interlocutory appeal. These are actually relatively rare. Well, they used to be rare. I think Mr. Trump has set a new standard in our legal system. So they're no longer as rare as they once were. And what happens then is that the trial can stop, so they can stay the trial, meaning everything stops, or they can deny the stay, which means that everything keeps going. But then the interlocutory appeal takes it up to the next level, which is the Court of Appeals, and whichever circuit you're in. We have in the Garcia case, we're in the Fourth Circuit. With the JGG case, we're in the DC Circuit. All right. And so whatever their answer is, you can appeal that if you don't like their answer. And then that is what goes up to SCOTUS at this point. So this is all paperwork. These are appeals are all paperwork. We're not even in the trial situation. We're not even in the evidentiary situation. We are just arguing issues of law. So that's how the appeals process works. Now, every time a ruling is made by the district court on a piece of evidence or on an order to the parties, it's possible to file an appeal. Now, should you? No, you shouldn't file an appeal on every single thing because that would be unethical. But if you don't have ethics, then yeah. So there's lots of interlocutory appeals going on here. This is what we're going to be dealing with both of these cases. It slows everything down. Now, SCOTUS has said, they recognize the timing of the situation, but also, again, the Court of Appeals doesn't have to accept the appeal, and neither does SCOTUS, but they're going to keep trying it. So anytime the court issues an order at the district court level, my thought is, yeah, they're probably going to appeal it and try to get it to the Supreme Court and drag it out as long as possible. Absolutely. I had no idea. That's my best guess. Most attorneys don't do that again because it would be unethical, but these attorneys don't care about the ethics of the situation. So hello, Kristen, welcome. So that's my overview of how the appeals system works. So you might think, well, how many appeals do you possibly get? Well, you could potentially appeal each order, and then we're not even in trial. And so once we hit trial, or once we get into more of the evidentiary piece of this, then each one of those things could be appealed. Technically, at this point, you know, if we're in the middle of a trial and the judge is like, there's an objection for hearsay, and the judge might say, overruled, that could be appealed. And you could have like 100 objections during trial. I mean, if you want to go down that road, there are, when you toss out an attorney's ethics, then, you know, there's a lot of other things that can happen to really screw a case up. Will it go to trial? Don't know. Don't know. Can they be reported to their state bar? Yes, June Marie. They can be reported to their state bar. Absolutely. And they should be. And they absolutely should be. I was cruising around looking for where they're licensed. The key is you have to know, you have to look and see where these people are licensed out of. And honestly, I just did not have enough time to go and look up where everyone's located. But if you can pull up their where they're located in their state, you can absolutely file a bar complaint. Absolutely, you can. So let's take a look here. We have a Yakov Roth. So this person right here. All right, so look this person up. And then this Drew Ensign, which he's got quite the reputation, actually. He's really not so good. And then we've got this John Blakely. Each of these attorneys right here, if you look up where they're licensed, and it might be in DC, the DC bar does have a lot of people. That's Giuliani and Eastman were both barred. They both had their licenses removed or were unable to practice in DC. So these three, in order to practice, they need to have an acceptance into court in DC. So it's very possible that they are licensed in DC, but also somewhere else. Yeah. If the appeals court doesn't take it, can the Supreme Court? So that's a really good question. So what happens if, the district court and they appeal to the Court of Appeals, and the Court of Appeals says, I'm not going to take it? It's possible, if it's a huge constitutional issue, they can apply to the Supreme Court and they can say, well, the Court of Appeals refused to take it. We need you to decide on it. And so it is possible to kind of leapfrog over the Court of Appeals, which is actually something Jack Smith had requested in the DC case. Had said, look, this is going to be a long road. Can you guys just take it and sort it out? And the Supreme Court said, no, take it to the Court of Appeals. And then they went through the appellate process. So it is possible to leapfrog over the Court of Appeals if the issue is important enough. But SCOTUS doesn't like that. They like to have precedent. They like everybody in their place and a place for everyone. So they like to make sure that it's walked through the process properly. Do you have to be a party to the case to file a bar complaint? No. Anybody can file a bar complaint, and it's an ethical complaint. So you've got to look up what ethical rule is in question. That's the key. If you just come in and say, well, they're a jerk, they're not going to really do anything. But we have model rules of professional conduct. This is from the ABA here. But what you want are the rules. These are kind of for the federal system, but what you want are the rules in the state. So in our state, professional conduct rules are just pretty much the same. The only thing that's different is some states have, certain exceptions here and there. But what you do, everyone, as I'm sure who all have the model rules of professional conduct tabbed out like I do, because they're dorks like myself. But what you do is you pull the rule out. Let's just look here and see. Here we go. Truthfulness in statements to others. So that's kind of where mine is at. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, right? So what you would do is you would say, I believe this attorney has violated Rule 4.1, and this is why, because they made false statements, they knew they were false, and so on. So that's how you do it. Hello, Katie. Welcome. Good morning. Good morning, Alyssa. So in this situation with most of the attorneys involved in the Department of Justice, I would say, let me pull the best rule out that I think we're having problems with here. Let me see. I have to make sure we have that. Oh, here we go. Maintaining the integrity of the profession. That's important. Reporting professional misconduct is set out in 8.3 if you want to look that up. Because we're actually required to report a lot of this stuff. We're mandatory reporters. Disciplinary authority. Hold on here. Let me look and see. Here we go. It's candor toward the tribunal. So it's Rule 3.3. Let's take a look at that rule real quick. That's really the key rule when you have someone jacking around the court system and not giving truthful information and not being respectful of the judge. That's the rule you're talking about. So right here, Rule 3.3, candor toward the tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer, or fail to disclose to the tribunal legal authority in the controlling jurisdiction. So if they know they were wrong and they know there's a case, they need to disclose that, known to the lawyer to be directly adverse to their position, or offer evidence that the lawyer knows to be false. So this is where, this is the rule, everyone. This is the ethics rule that we're dealing with, where we have the Department of Justice attorneys who are not giving appropriate information to the judge and are being disrespectful to the court. It's Rule 3.3. So that's the one you want to look at. You can go online and put in, how do I file a bar complaint? After you've located the jurisdiction where that person is licensed out of. All right, so it's a couple of steps. Let me just write the steps out real quick and then we can dive in here. So, oops, my learning pad's done here. That's all right. So step number 1, you have to determine where they're licensed. All right, for each attorney licensed. All right, number 2, you have to find the rule that they're violating. Find the ethics rule. And I would say definitely 3.3, candor to the tribunal, is probably the biggest one. There are multiple, but that one would be the biggest one right now, in my opinion. And then online, what you do is you pull up bar complaint is probably the best search here, or how to file. And then what happens is they'll pull up a bunch of forms. And if you want to really hone in on it, you can say how to file in whatever state it is. Could you do a post about it? Yeah. I think I've done some posts on ethics before, but yeah, we really need to dive into that. For sure. Yeah, I can put that together. But the thing is, when you're filing a bar complaint, just to give you a little insight, everyone, is that you need to have some evidence to back it up, right? So because they're getting complaints all the time. They're like, oh, you don't like your lawyer, they didn't get you what you wanted, so you're mad. But if you pull a rule out, like candor to the court, and you include, for example, the order that, the contempt order that came out of the JGG case, all right, that would be huge. So if you put that into the complaint and even pulled the paragraphs out and said, the judge said that they were not being candid with the court, that they were being intentionally obtuse and not doing it correctly, that right there, the whole opinion's really ethical violations left and right. And then also we have the latest order from the Garcia case, where the judge said that they're not complying at all with her orders. That also would be ethics violations. So just with these two cases, the Garcia and the JGG case, the most recent orders absolutely would have 3.3 violations in them. So, and again, this is under the American Bar Association numbers, but whatever state they're licensed in, they're going to have a number very similar or a rule very similar. And again, this is the candor to the court piece of that ethics. All right. So you want to cite that and say, look at this decision, we're not having candor here. And to pull that evidence in, pull that decision in, just gives you a lot more credibility for that. Yeah. Oh my gosh. Oh, Kristen. Oh, thank you so much. Thank you. But if I file a complaint and the bar chooses not to act, can I be sued? No. No, you cannot have any kind of retaliation towards you for filing a bar complaint because our ethics, we self-monitor. Like I actually would get into trouble if I didn't file an ethics complaint. Now, I'm a little bit... I look to the attorneys in the state that I live in, so I don't really go outside of my state unless there's a really big situation, like with Judge Cannon in Florida. They flooded the bar in Florida with Judge Cannon. They flooded with complaints. So the bar there actually said, look, can you stop? We have thousands, and it'd be great if you could stop. We're looking into it. It's all the same issue. We're looking into it. So... that's one of the things. Now, what they do for the ethics complaints is then they go out and they do an investigation. They look into it and they figure out whether or not to open the case or to close the case. So they've got their own investigators that do that. And if they open the case, then it walks down that road for just like any other kind of litigation. It walks down the ethics litigation road and they'll make that determination. Yes, hello, Snappy. Yes, I'm trying to be careful. Oh, absolutely. Yeah, as a 3L, this is a very important information. And as a 3L, you should really know these rules inside and out. There's really not that many of them. But when you just break them down into the different categories, again, this is kind of my tip for you when you're getting ready for the bar exam. But when you break these down just into, I think there's 1, 2, 3, 4, 5, 6, 7, 8. There's 8 categories. That's it. There's just 8 categories. So if you break it down, it's very easy to go through and really know what these rules mean. Actually materialize out of the canon complaints. So great question, and I don't know. I do know that these kinds of investigations can take quite a while. From the time that it's filed until the time that you actually hear something could be 18 months. Could be more than that. Because our system works so slowly, because we are so thorough in the process. So right now I just don't know. I would assume it's already open. Oh, you already have an ABU membership. Great. Yeah, that's great. And then, after you graduate and pass the bar in whatever jurisdiction you want to work in, then that's when you can start going out into that jurisdiction and seeing what their bar is there. And you'll get your court number and so on. Can you include multiple attorneys on a bar complaint? Do each attorney separately? I'd recommend doing it separately. I think when you, quantity can be incredibly helpful. So rather than condensing it like these 3 attorneys that filed this crap, instead of just putting it on one form, it's one for each one. And they may be out of different jurisdictions too. So that's another thing to keep in mind. And also, part of our rules here, everybody, for ethics is maintaining the integrity of the profession. So when it comes to misconduct or speaking negatively about judges and other attorneys, that's actually an ethics violation. We have to be very careful about our language. But if our language is supported by facts and evidence, and what we're saying is at a point that's really indisputable, that's why I'm okay saying these attorneys have some problems, because we do have orders. We do have judges that have already called them out on their bad behavior. So for me, I'm well, you've got a public order in place, so I'm not the one that's breaking the seal. You know what I'm saying? Yes, he does. He does it all the time, but he's not an attorney. So that's the other thing. Our ethics rules are just for licensed attorneys, and as a licensed attorney, we're not supposed to be, bashing on judges. So when you see other things, like, I don't know, is Marco licensed? I think he's licensed right out of Florida. Any of these dingleberries that are licensed doing this kind of stuff and speaking to the judges this way, those are the ones that we're talking about here. What about the Supremes? They have, there's been some talk about how to go forward. They do have ethics rules that they adopted like last year, I think, or the year before. I'm getting mixed up. They finally have adopted an ethics code, which is great. They've never done that before, but there's really no way to implement it. There's no way to truly make a complaint, although you can certainly try. But yeah, it's difficult. And the problem is, of course, with the Supreme Court is that, a lot of people would be like, oh my gosh, they're terrible, they're awful, which is fine. But, where's the rule? What's the rule that was broken? Where's the evidence showing that the rule was broken? So I would say if you want a really valuable complaint against the Supreme Court, the U.S. Supreme Court, go back to the articles of impeachment that were filed against Thomas and Alito. They set out the rules, the ethical rules that were violated and the evidence to support it. So I think that's very helpful. Although it hasn't been pulled out of, I don't know if it's even been brought up in committee or not. So those articles. Right. So that's the ethics talk. And the reason I bring it up is because we have an appeal that's been filed. This was filed yesterday. This was filed when I was actually online. But then this morning I was like, this is really important stuff. Let's talk about it. So hold on here a second. Let me get myself sorted out again. Okay, what's this? Page 2, right. Page 47. Oh, okay, hold on, everybody. I'm all mixed up now. Oh my gosh. I tell you, if I don't color code my stuff, I really get into quite the mix up. I would say here, 2, and then we have our interrogatories here. Key 44, 2, right, 46, 47, 48, 49. Okay, here we go. Flip it back over, and then this is 18. So let me bump this down. I split my stacks, everybody, to find the attorneys. So here we go. Let's start at the beginning, right? We'll do Sound of Music style. Here we go. Good morning, Mary May. Good morning. Right. So again, the best rule, just real quick, everyone, if you are going to go forward on ethics complaint, first you've got to decide where the specific attorney's licensed. You got to find that out, and that's all online. Next, you got to find the rule that's been violated. 3.3 is candor to the court. So if there's bad information being given to the court, or the court's being disrespected significantly, that's going to be Rule 3.3 at the federal level. The states will have their own numbers for their own candor to the court. And then you go online, you pull up the bar complaint for whatever jurisdiction that is, and then you go forward and just fill out the information. All right, so that's the quick explanation on how to file a bar complaint here. So, does being AG insulate her from disbarment? No. The only thing that insulates anyone from disbarment is how incredibly slow the process works. That's really it. It just takes a really long time. Like, for example, I think Eastman just lost his license, I think it was just over the summer, actually, where he lost his license from his actions in 2020. So what he did in the 2020 election, he had his license removed for, but again, we just had it this past summer. would state federal court fall under state or federal rules? You're going to have both. You're going to have two. You're going to have a state license, and you have to have that because once you're licensed in any state, then you can go into DC and pick up a license there. Yes, hello. Oh, from Australia. It takes a lot of time because we're very careful, right? So the slow and steady that everybody says, that's the legal field. And it really takes a long time. But that means when we get to the end of it, it should be correct. We should not have a lot of mistakes because we do take our time with it. Okay, here we go. Yeah, I need to do a post on that, June Marie. I think that's a great idea, Kaya. So I will make a note to do that. This was filed yesterday, everybody. I'm going to kind of skim through it because I'm not going to be able to, read the whole thing. It's 258 pages. But there were a few things that I thought, well, let's talk about it a little bit here. Go to prison. Right. So, exactly. And, Giuliani, Eastman, let me double check here. There were some attorneys. Hold on here. Hold on. Whew. Here we go. So, Miss Ellis has had her license pulled. Miss Powell has not. She's out of Texas. Cheesebro has had his license pulled. Jeffrey Clark has had his license pulled. He was really upset about it. Eastman has had his license pulled. Giuliani. I'm not sure about Smith. I think, this case is still ongoing, so we don't know yet about that. But Ann Cheely also is an attorney, so I don't know if they've got ethics complaints filed against them. I would assume so. So we've got, so like pretty much everybody has had their licenses pulled. Yeah, Cohen. Yeah. All right, so here we go. This was filed yesterday. Now, I did a quick post on an appeal that they had filed for her, for the judge's order from April 10th. And what they did, they went back in and, gave more information. So here we go. We have an emergency motion for a stay pending appeal in the petition for a writ of mandamus or mandamus, depending on how you want to pronounce it. Let's talk real quick. A writ of mandamus or mandamus is basically requesting the court to force a government employee or someone who is working for the government to do something. That's what this is. So if you see a writ of mandamus on file, we don't use these very often because they're basically asking the court to force another court to do something, rather than asking for an appeal or asking for, a reversal of opinion, whatever. This is they're asking the court to demand conduct change of a different court. So it's a pretty serious writ. This is a very serious. Right. Mandamus. Well, good luck, Mary. I wish you well on that adventure. Yikes. So again, as I was talking before, in our appellate process, they are appealing here to the Court of Appeals. And so they're asking for their case to be paused. This is the Garcia case. Let me just read the first couple intro paragraphs here. Is it bunker time? I'm getting it cleared out. I'm getting my bunker cleared out. I'm not sure if the time's there yet, but I've got to make sure it's ready. So Article 2 of the Constitution bestows on the president and through him, the executive branch, the exclusive power over foreign relations. And for those of you that tuned in last night, when we talked about the contempt issue going on in the DC case, the judge in that case said, well, no. Foreign relations is not an exclusive power, right? So Congress has lots of power, and our courts also have powers, right? They listen to other cases, like Mexico just sued the U.S. not that long ago, sued a company in the U.S. So they're also involved. So that's not true. The Supreme Court reaffirmed that principle in this very case, unanimously rejecting the district court's unprecedented command that the executive actually effectuate, oh my gosh, the return of Abrego Garcia from El Salvador. So I guess what they're doing here is they're trying to make their case for the gaslighting they've been doing. So they've been going and saying, oh, we won, Trump won. And what they're doing here now is trying to explain it and put it in a court document on how they won the Supreme Court's decision. force a foreign sovereign to relinquish one of its own citizens. Under the guise of an amended order, however, the same district court has set down the same unjustifiable path, all in service of a member of a foreign T organization with no valid right to be in the United States in the first place. Again, this is all not true. This court's immediate intervention is needed. So the problem, usually in our courts, we have a fact finder. That's our jury. All right. We have, and it can be a judge. So our judge or our jury is a fact finder. And what happens when you don't have due process or when you appeal an interlocutory appeal, like mid situation, is that you don't have a fact finder other than what the judge is reviewing on the record. And this particular record is pretty sparse because the government's leaving it pretty sparse. So by them coming in and saying that he's a member of this group, we don't have proof of that. We don't have any proof because there's no due process. So the defense attorney is basically saying, well, just trust me. He's just, he just is. And he's asking the Court of Appeals, like, oh, well, just trust us, even though they've had all these huge problems. So that's an issue. That's a huge issue. Because, again, the problem with no due process is that we don't have a stable set of facts to rely on. We have, different filings that they've done of various people, and even one yesterday that was incredibly offensive, but that's not evidence. It can be, even if it's reliable, it's just hearsay. It's not full provable evidence under the rules of evidence. And that's what happens when you do declarations or affidavits, right? So to kind of bring it back to the 2020 cases, the election cases, one of the problems was that the team that was saying the election wasn't so good was relying on a set of affidavits from just some people that are like, well, I saw this and I saw that, and it was affidavits and they signed it. And it's like, well, okay, that's great. But if you don't have any corroborating evidence, you're just taking some word of somebody who's like, well, I think I saw him move a box. Like, that's just not enough evidence to sustain your burden of proof. Some word of somebody who's like, well, I think I saw him move a box. Like, that's just not enough evidence to sustain your burden of proof. There we go. Okay. Oh, I'm trying to be careful so the live doesn't go down. All right. So that's, welcome to family court. Oh my gosh, that's a completely different animal, nightmare animal. So again, that's why we can say, if they come in and say, well, this is this and that is that, like, we don't have any proof. We just don't have any proof to support that. And I'll tell you one thing, judges, it doesn't matter if you're a Supreme Court justice or if you are a magistrate. Judges do not like to just make decisions on trust me, bro. They want evidence. They actually want evidence. It's just in their DNA. So that's kind of how that goes. Right. But exactly. But we can't prove it one way or the other. Now, our rules of evidence, again, and they might say, well, who cares? We have our evidence. The reason why we have to have rules of evidence is to make sure that the evidence is trustworthy, is authentic. And so it is actually the opposite of proper procedure to just say, well, we just know. Like, the judge is going to be like, what? Are you under oath right now? Like, are these attorneys under oath when they're filing this? Because we've seen ethically their candor to the court, isn't applicable because they just don't do it. So how do we know that this is actually a truthful statement from these lawyers? And that's the problem when you lose your credibility with the court. Anything you file now is going to be questioned. And if you don't have the receipts, you're going to be not taken seriously. They better. Exactly, Heather. Exactly right. All right. So here we go. So this is all, the federal courts do not have the authority to press the president or his agents into taking any particular act of diplomacy. Like, where's your cite? Let's just ask that question. Where's your citation? Instead, in this context, the courts only have the authority to order the executive to facilitate the return of an alien removed abroad. And again, where's your citation for that? And as that term has long been understood and applied, that means the executive must remove any domestic barriers to the alien's return. It does not, and constitutionally cannot involve a directive to take any act upon a foreign nation. Again, where's your citation for that? Like, how's that? Is that just what you think, attorney here? Or, is that like law? So, I mean, that's a problem. The lack of citation. It really is. I mean, and they've done that over and over and over again. Although one of my favorites is the declaration where he just cited the prior declaration of another person. He's like, well, according to the guy that filed his yesterday, that's not effective. The district court, though, has again crossed the line, notwithstanding the facts defendants have filed a declaration affirming that the United States is in the process of removing domestic impediments to any return on the part of Garcia, a member of the foreign organization. Again, there's no proof here. We don't have that proof. We don't have any facts or evidence to support that because they didn't have due process. If they had given him due process and they had proven this, we would be walking down a different road. If they had said, here's the evidence we have in front of a judge when Garcia was there for due process, we wouldn't even be here. But they didn't. So we don't know. And we don't trust them because, we have rules of evidence. Who no longer has any right to withholding of removal in the first place. According to what? Again, what's the citation of that? Just some guy said it. Like there's no court citation. The district court has demanded more. It has ordered the executive to go beyond the long-standing understanding of what facilitation requires, necessarily going beyond what Article 3 allows a court to do. And where's your citation? Do you have a case for that? Or are you just, writing it out on a napkin at the pub, In the setting of a case involving a citizen of a foreign sovereign who is a member of a foreign organization held in the domestic custody of that sovereign, there's no question that the executive's foreign affairs powers are at their apex. Because of what? This is absolutely ridiculous. There are no citations to support anything that this attorney is saying. There's nothing to support this. He's just saying it for funsies. Yet here, a single district court has inserted itself into the foreign policy of the United States and has tried to dictate it from the bench. Emergency relief is needed. Like, that's an opinion, so you don't have to cite that. But, the rest of this stuff where you're saying they're violating the law, like, what law? You can't just say, well, someone's breaking the law and then not cite the law. That's like what you do as a lawyer. You use the law. Where's your law, dude? As bad, while the district court has rejected this well-established definition, why are you quoting this? Where are you quoting this from? This is just basic English now. Where's your citation for your quote? Here at 2, Sotomayor's statement respecting the disposition of the application, again, it refused to provide any sort of definition of its own. Well, that's not true. And worse, again, there's no support. And worse, it then ordered extensive and expedited discovery into the executive branch to probe how it has or might effectuate this ill-defined directive. The result is a fishing expedition. So if you weren't with me when I read through what she was requesting, she had said they could depose every person that had submitted to the court their declaration. All right. She said, you can depose these, I think it was 5 people. These 5 people who submitted declarations to the court as proof of what you're doing, which didn't actually include that proof, you can depose them. And you can have 15 interrogatories, which are questions. You have 15 interrogatories to figure out what's going on because the government's not giving any information. So I don't know if that's a fishing expedition because they're asking the same questions that the judge asked. I'm not sure that's fishing. Maybe they plagiarized. Well, it could be. Yeah. I mean, there's one declaration where the guy's like, the court has no right to this. And the citation is, well, because I said so. Captained by plaintiffs armed with an open-ended mandate, who have already ordered scores of production requests. They had document requests included with the interrogatory requests. Those are set out by the judge. Burdensome interrogatories. This is where I would say, have you never seen an interrogatory before? All interrogatories are burdensome. Like, this just shows the lack of experience in court. My least favorite thing in the legal system are interrogatories. Well, maybe not. My least favorite thing is reading through the answers to interrogatories. And at least 4 and perhaps more depositions of executive branch officials. And again, she had listed only the people who had filed declarations. That's it. Like, they've already sworn that what they're saying is true in a statement that has been pretty much useless and filed it with the court. So she's saying those people that have already filed stuff with the court, you can depose, right? So, there's that. At minimum, that is untenable and mirrors mistakes regarding governmental discovery that other appellate courts have corrected in mandamus. Where's the citation? Like, what cases are you talking about here? Like, in what cases have other appellate courts corrected it in mandamus, right? What other cases? Anyone? Bueller? No? This court must act. An opinion, that's fine. It should stay the district court's amended injunction, which extends beyond its equitable authority, and it should grant mandamus to direct the district court to vacate its capricious discovery order. In the meantime, defendants respectfully request this court issue an immediate administrative stay. Counsel for plaintiffs were contacted by email and notified the undersigned that they oppose this motion. Okay, well, at least they talked to the other side. Now, keep in mind here, the Supreme Court has said to the district court, your order's fine, just clarify some of, let's tighten up this language. So she did, and then ordered a discovery, which is what she's supposed to do as a judge. So the Supreme Court already knows she's going forward. And here they're saying you need to stop the proceedings that have been ordered to continue by the Supreme Court. Like, this is, we don't want to. We want the Court of Appeals to tell the judge she can't go forward with what the Supreme Court told her to do. Well, we don't want to toss the baby out with the bathwater. I know that's an old statement here, but physically remove and overthrow the entire system. So here's the deal with that. Here's the deal. Not everything doesn't work here. We have someone who's twisting up a lot of crud here because it needs to be tightened up, and we need some rules to be like, well, if we have someone who's going to abuse their power, then what rules do we need in place in order for these rules to not be used as a way to take over? But, we still got a lot of stuff that still works here. Stalling technique, yes. Do the same thing, yes. They did do the same thing. Absolutely, they did. One of the biggest things, and I know history may not be why you're here, but one of the biggest reasons why we even have a constitution is because we had the Articles of Confederation. They didn't work. And so the question was, the biggest question between the two sides of that argument. One side was saying we got to chuck it out and start over. The other side was saying we just need to fix what we already have or wait for the Articles of Confederation to actually work. We don't need to draft a whole new thing. That was the entire fight. So that's why we have a constitution, because the side that said we need to start over actually won because it was a problem. So, I mean, this is it's an ongoing issue that we have. When they wrote the Constitution to make it malleable so that it could be adjusted depending on what's going on. There you go, free history lesson, everyone. Here's our statement here. Now, I'm skipping through. Again, this is 258 pages, this filing, and it's not them making arguments. It's, additions to stuff. So this is their set of statements. And again, because they are completely untrustworthy, I'm not going to read through this because I believe it's false information. Truly, it is. And I don't want to bring false information to light here. Standards of review here, they're citing the Enkin case, which they've done before. And then here's our argument that they're setting out. The district court's amended injunction is unconstitutional. Here, Alfonso, I have so much bias because these attorneys are so unethical. That's absolutely true. And in fact, according to the ethics rules, if I'm not biased, I'm being unethical because they've clearly violated their ethical rules. So I don't want to shed any light onto false information. So there you have that. All right, I'm going to skim through this as well because I want to get to the interrogatories. Let's see what they are asking. Let's see what questions they're asking. So we've got the argument, the district court's amended injunctions unconstitutional. Again, this is that order after the Supreme Court here. So they're arguing that do all search warrants look the same? They all have the basic same structure. In the Constitution, it's actually interesting because some of the language that you have to have on a search warrant is in the actual Constitution. So that's kind of cool. So there's some pieces that are all the same, but every jurisdiction's warrant will look a little bit different depending on your jurisdiction. So you can just look that up. You can look up search warrant and then your jurisdiction, and you should be able to find some examples. All right, so the district court's discovery order must be vacated. So let's look at that before we dive into our interrogatories here. Let's see what the big whoop-de-doo is here. I know, citations? I'm shocked. I almost fell off my chair. Hold on, I fell off my chair. So here we go. No discovery is appropriate in this case. What? Oh my goodness. What is happening in the legal field? No, I can't. I gotta take a drink of tea. 1 minute. Oh my goodness gracious. Oh my gosh, I'm just screaming in my mind, everybody. Okay, no discovery is appropriate in this case because we're big fat jerks. Oh my gosh. All right, because defendants have done and are doing exactly what the Supreme Court's ordered. How so? Do you have any proof of that? You have any proof of that? I don't care if he's a citizen or not. I just don't care. That's not relevant to me. Is he human? That's the question. Is he a human being? Now, if he was not a human being, right, then you'd have a good point. But if he's a human being, that's it. They are removing domestic impediments to Garcia's return. Oh my gosh. Facilitating that return. But even putting that aside, the district court's discovery order harbors fundamental infirmities. I just feel, all right, listen, it's just so ridiculous. I'm struggling because you think like, if you go back to the whole signal situation, right? Where this group of dingleberries was like, well, other people use signal. We're going to use it too to plan blah, 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 blah. Why can't we? So I feel it's the same thing here. They're like, well, other people say blah, blah, blah. So we're going to put it in a filing. It's like the law doesn't work that way. Yes, so the Supreme Court has long recognized that a discovery order that improperly intrudes on the separation of powers satisfies the requirements of mandamus. Oh, look, Here's a citation, everybody. I mean, it's not a good citation. That is the case here. Wait, do we? I don't know. Whatever. I'm not going to even judge them on their citations. I'm going to say, good for you. Good for you for citing a case. Oh my gosh. All people get due process under the 14th Amendment. That's right. Right. That's right. This is the case here. At true minimum, the district court should have put forward a definition of facilitate. Boy, they're really using this word. Before ordering invasive discovery into the executive branch. But that court refused to do so, failing to offer any guidance beyond rejecting what defendants proffered. That does not work at all. What? Like, I'm sorry, that time doesn't work for me, Supreme Court. We're not going to do that. No, that's not. I would get my red pen out, but it's just so painful. Before going down the road of intrusive discovery, like, have you never seen discovery before? Into what defendants have done to date and what they will do in the future, it was incumbent on the district court to define what they were in fact supposed to do under its order, which she did. The alternative leaves a moving discovery target at best and a blank check for plaintiffs at worst. So this is where I'm wondering if we've got some, AI situations going on, because this should be carte blanche is what we usually say. Carte blanche. We don't just say blank check. Oh my gosh. For plaintiffs at worst, this court should grant mandamus and order the district court to first decide this threshold issue. A threshold issue. So they're saying, we're not going to do anything until you decide what we want you to decide. Like they think that they've got some kind of power here. We're telling the appellate court to tell the district court what we think they should be doing. Like it's just, goodness gracious, everybody. Ordering discovery into a separate branch of government is a weighty step that should never be taken lightly. Oh, and we've got another citation here, and I think it's properly cited. Good for you. Well done. At the very least, respect for a coordinate branch of government requires a federal court to resolve all threshold issues before taking the extraordinary step of ordering discovery. So again, according to what? I mean, are you continuing to quote the case here? Yeah, so what? Indeed, the DC Circuit recently stayed a discovery order into the executive branch for this exact reason, where the district court failed to first resolve a pending motion to dismiss. In re Musk here. Now, hold on a minute. In re Musk, right, I've read that case, and this just happens to be, a procedural question about a motion to dismiss. We don't have a motion to dismiss in play here, so I'm like, why are you citing that? And then going back to the Cheney case, like, okay. Yeah, this was not very long ago, the In re Musk situation. And this case is going to drag on so long that even if Musk gets out of town, he's going to still be having to deal with that. Good luck for that. Those principles apply here in full measure. The district court ordered far-reaching discovery to probe, in particular, what added measures defendants are able to perform to facilitate Garcia's return. So hold on a minute. They're saying here, ordered far-reaching discovery here in order to ask what they can do. So they're saying it's far-reaching, but yet they're defining the parameters. So yeah, I don't know about that. But so long as that term is undefined, God, they're such jerks about this. Discovery will necessarily become open-ended, not open-minded. The result will be a fishing expedition, which is improper even in ordinary litigation. All right, so that's enough of this crap. They go on and on, whining about their bologna sandwiches further, blah, 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 blah. And talking about why they get to have mandamus. The equities demand relief. Again, I'm going to skip through this because I want to get to the interrogatories, everyone. So skipping. Skipping, and it's probably all wrong. So again, these are the 3 attorneys where you can feel free to look them up and where they're licensed, and then read through Ethics Rule 3.3 of the American Bar Association, and then check and see if the court order that was just put out would fit into that bar. I'm just saying. I'm just putting that there, okay? Oh, Alfonso, your words hurt because I have so much respect for you. All right, here's our certificate of compliance with tight volume limits. So they're like, we followed your rule, Judge. So then we move on. Table of contents here. Screenshot. Back we go. Here we go. Let's do 5 seconds. 1, 2, 3, 4, 5. There we go. I don't think they're anonymous. I know, but also you cannot be retaliated against if your name's in there, and it is kept private within the ethics group or committee that's in charge of ethical violations. That is kept private. So here, practicing attorneys just on paper only. They should be practicing attorneys, or else they should not be filing any kind of motions. Here, court's ability to reign abuse of power. So 1526, I have no concerns about whatsoever, because it is actually it's in violation of the Constitution. And if they want to make those kinds of changes, they would need a constitutional amendment, right? So we had some questions before, like, can they pass, let me give you an example. Can they pass legislation to allow a president a 3rd term? No, they may not. They'd have to pass a constitutional amendment. So this kind of a change that they're trying to do to kind of walk over a Supreme Court decision requires a constitutional amendment. That's, a piece of legislation is not going to do it. All right, so fast forwarding here, we've got notice of deposition. So let's take a look at this. This is the part I thought was interesting. They were given an order, so these are the plaintiffs. They were told you can depose the people that put their declarations and filed into court. Yeah, no rewriting of the Constitution. There's not enough votes for that. And thank goodness. So here we go. We've got a notice of a deposition. Here we go. Plaintiffs here, and by and through their undersigned counsel, will take oral deposition of Michael Kozak. So he was the first fella who filed that declaration saying, I get to decide whatever I want, and I don't have to tell you anything. So this is the date and time of when that deposition is supposed to be occurring. Will be conducted before an officer or administrator. Oaths, getting anyone under oath is incredibly important in this situation because nobody's really trustworthy. Yes, they are walking over it, but this is the executive branch walking, not the legislative branch. The deposition is being taken for the purpose of discovery, for use at trial, or both, or for such other purposes permitted under the rules here. So they are asking for deposition from Mr. Kozak. Let's see who else is getting asked. We'll put that man under oath. Now, he can take the 5th if he wants, but let's hear him take the 5th. Let's hear him take the 5th for every single question, much like Mr. Trump has done in the past. Next, we have another civil procedure situation where they are requesting the oral deposition of Robert Cerna. So again, he's the next person that put a declaration on file, claiming that what he was saying was true. Again, we don't know. That's why we need a deposition here and to fill in the blanks of what's going on. And if they try to say, well, I'm not going to show up, it's a court order, so we could issue a warrant. We could have a warrant pulling these people in and being like, well, you're in jail until we get the deposition done. Like, well, what are you doing today? I'm continuing to sit in jail because I violated court order. All right, well, let's do a deposition. Oh, my gosh. All right, you got to find the silver lining, everybody. Joseph Mazzara. Now, this fella, this attorney right here, he's no good. This is a huge 3.3 violation. This guy is such disrespectful to the court by a lot. And his filing just yesterday is so offensive. I can't even believe an attorney would file it. He's originally, I think, out of Texas. He worked with that crooked AG down there. And then he's continuing on his ways, with his ways. So this guy is, he's no good. He's no good. So they're trying to, again, they're setting up the time and place for his deposition on that one. Yeah, Paxton. Thanks, Jen. Sometimes I forget the name of bad people. Like that guy that shot Lincoln. I don't remember his name. All right, next we have another deposition, and this is Evan Katz. Again, another person who had filed the declaration. Let's just look and see what the dates are here. I'm noting this. So April 23rd for this fella, April 22nd for this fella. They're setting up the dates and times again for these depositions. And they can come in and they can say, well, right. I intentionally try to forget his name. Here we go. And, oh my gosh, I'm loving this as well. So plaintiff's first set of requests for production to defendants. And they set out the definitions, everyone. So we have this, like, peter around, play with definitions. Let's be, jerks. So the plaintiffs are like, well, these are the definitions we're using. Number 1, Abrego Garcia means the plaintiff. Kilmar Armando Abrego Garcia. So important. CCOT here is the confinement center. Communication. They're defining communication. You have to, because these guys are just being absolutely ridiculous. So communication means any transmittal of information in any form and of any kind, including any electronic, oral, or written transmission. Oh my gosh, these plaintiff attorneys are just cracking me up. I'm sorry. I gotta take a drink of tea. Hold on. They're like, this is what a communication is. Oh my gosh. It's smart. It's very smart what they're doing. Very smart. You gotta, get ahead of it. Get out ahead of it, everybody. A document. Okay, now this looks good. So a document means any information stored in a medium from which the information can be obtained. A document includes, but it's not limited to, any calendar, chart, communication that's listed up here, data or data compilation, database, diary, draft, drawing, electronically stored information, email, fax, floppy disk. Oh my gosh. Graph, hard drive, image, index, instant message, letter, log, magnetic tape, memorandum, a note, optical disc, photograph, report, sound recording, spreadsheet, storage device, text message, voicemail, writing, or any other category covered by the rule of civil procedure 34A1A. My goodness. Oh my goodness. Just a minute, everybody. I'm sorry. I gotta wipe the tears. I can't. Oh my gosh. They're like, you're not screwing us over, people. We're gonna get it all covered. Oh my gosh. Oh, the microfiche. No. They forgot that. All right. Or anything under this rule here. So they're being pretty clear about it. Let's just look this rule up here for fun because it makes me laugh. All right. 34. Oh my gosh. Okay. 32. Let's look up. We've got, let me pull it up here. 34A1. My goodness. 34A. Oh, we're in the wrong place. So rules of civil procedure, 34A, 1A. I don't know if they cited the right rule here. I'm not sure that rule is correct. Well, anyway, we'll move on. Oh, I get it. Look at that. That's criminal procedure. Sorry, my bad. My bad. There's the civil procedure. Oh, You know what? I think I left it in my car. Sorry, everybody. I was so excited. I'll have to look it up later. So civil procedure, it's actually a green book. I must not have brought it in. Anyway, whatever. So they're being very careful here. Next, facilitate has the meaning ascribed to it in the order granting expedited discovery. So they're like, well, and this word means what the judge says it means. Oh my gosh, that's so funny. And then you and your, my gosh. Oh my goodness. You and your means the defendants in this case, including, as applicable, any of their officials, employees, departments, components, commissions, representatives, agents, attorneys, assigns, predecessors, affiliates, third-party experts, service providers, and any other entities, instrumentalities, or person acting or purporting to act on their behalf. That is the best definition of you and your that I've ever seen. That's the very best one. Oh my goodness. Oh, all right. Oh my gosh. All right. I got to pull myself together here. Be professional. All right. Here we go. And again, we're going through this because I wanted to take a peek at what they're requesting here. Let's take a peek. Here's our instructions that they, again, are sending to the defendants. We've got, which includes you and your. Oh my gosh. Here we go. They know how to use pronouns. That's funny. Number one, time frame. Unless otherwise stated in a specific request, these requests seek responsive documents from January 20th of 2025 through the present. Responses respond to each request for production by producing each requested document in its entirety, along with every family document, such as any appendices, attachment, cover letters, enclosures, exhibits, and schedules that is in your, they're capitalizing, your possession, custody, or control. If no document is in your possession, oh my gosh, what happened? What happened at this hearing? Possession, custody, or control is responsive to a particular request. Provide a written response stating so. Construction. Construe each word in these requests in the broadest manner consistent with the federal rules of civil procedure, the local rules, and this court's rules. Oh my goodness. Production date in accordance with the court's order granting expedited discovery. Produce all responsive documents as soon as possible on a rolling basis and no later than 5 p.m. April 21st. Objections. If you do not respond to a request in whole or in part based on an objection, state the objection and the basis for the objection in writing and with particularity. Respond to any portion of the request to which you do not object. Oh my gosh, everybody, this is just cracking me up. Privilege. If you withhold or redact any responsive document based on an assertion of privilege, provide a log setting forth with specificity the nature of the privilege and the information required by the Federal Rule of Civil Procedure and Guideline 10D of this court's discovery guidelines. Form of production. Produce each responsive document in accordance with any applicable order or agreement regarding the production of documents. In the absence of any applicable order or agreement, produce each responsive document as it is kept in the ordinary course of business, with all metadata intact and with Bates numbering. So I think they're being pretty clear. Does that mean the defendants will respect that? No, but, at least they're being very clear. Serve all responses and productions on the undersigned attorneys via email at here and at here. If email is impractical, you can serve responses or production at the following address here. A continuing obligation. These requests are ongoing. If after responding, you obtain or become aware of additional responsive document in your possession, custody, or control, then produce that document promptly in accordance with the federal rules of civil procedure. Right. All right, so let's take a peek. I'm just going to grab a few of these, everybody, just to kind of take it easy on my throat here. All documents concerning each action you have already taken or plan to take in the future to facilitate Garcia's release from custody. All documents concerning each action you have already taken or plan to take in the future to facilitate his return. All documents reflecting any request to release Garcia from custody and any responses thereto. All communications to or from anyone in the government of El Salvador or at the facility concerning him. All documents concerning the legal basis for Garcia's confinement. I think this is really important. What's your legal basis? That's what happens when you don't have due process. So again, and then just going through, I won't read through all of these, but they were able to, ask these questions like, without regard to for time frame, all documents that you contend support your assertions that Garcia is a member of this group. So they're saying, well, show us what you've got. Show us your evidence that you say he's part of this group. I'm sorry, everybody. This is my chopsticks pen. I've just been feeling like the chopsticks pen is the best right now. So I've got a lot of that going on here. All right, so same thing here, and then they set out again another set of definitions for the interrogatories. Interrogatories are questions that you ask the other side. You only get a certain number of them depending on your jurisdiction. You can get like 25 plus an additional 10 if the court allows it. So this is very, very tight structure to having questions. Interrogatory number 1, describe with particularity each action you have already taken and when to facilitate Garcia's release here. So now they're actually asking these questions. These would probably be the same questions they will ask in depositions, right? Again, in order to facilitate his return in the future actions, each action you plan to take again, when it happens, identify, describe the role of each individual who's been involved. Yikes. Or whom you anticipate will become involved. Let's see. Each request for his release needs to be explained. Describe each communication you've had with anyone in the government of El Salvador or the facility concerning him. And describe with particularity the legal basis for Garcia's continued confinement. And I mean, again, these questions are exactly what they're going to ask during the deposition and supporting the document production here. So describe with particularity the complete factual basis for your assertions that Garcia is a member of this group, including by identifying the source of that information. Again, they're just trying to say, well, you said he was part of this group, so tell us how you know that. Identify and describe the role of each United States official or employee who has knowledge of the facts alleged in the complaint or of facts alleged in your submissions to this court, the Fourth Circuit or the Supreme Court in this case. So pretty broad. And our interrogatories are kind of meant to be that way. That's why they're such a nightmare to have to fill out. But there we have it then. And again, this is a filing by the defendants asking for the Court of Appeals to stop the case. Everything, they're asking to stop everything, to bring him back, to figure out what actually happened, all of the court hearings, everything, like the daily updates. They're saying to the Court of Appeals, stop the case and, have some kind of a hearing or determination about what the word facilitate means. Well, they have to answer, again, we're playing by different rules right now because these attorneys don't follow the rules. So technically, you're supposed to swear that you're going to give it your best shot. And if you can't answer the question, you write out why. Or if you object to the question, you write out why you object. Or if it's privilege, you write out what the privilege is and how it applies here. And then you just answer what you can answer. That's typically how it goes. But with these guys, I have no idea. I mean, they're just kind of like, slimy jerks. That's the best I can do. Because they're just kind of, when you toss out your honor, if you toss that out, then, all the rules, all bets are off. And, that's what's going on here. It's very concerning. Yes, these attorneys need to be called out. Absolutely need to be called out. Right, that the judges say no. And the Court of Appeals can do that. If we get to a point, and I feel like we're getting close to that point, that they're like, you guys are way out of line here. One thing to remember again is that our judges want people to do what they tell them to do. They want that. If you make a mistake, just fix your mistake. Go forward. We want things to work. We're not trying to make things extra difficult for people. They're already difficult enough. So what they want is just to have that. Asking about the administration says for... Right. Well, I guess I would put it this way, VC. One of the best ways that I can put this is, if a government person is not under oath, there's a high likelihood they're lying. All right. I'm going to just say government. Now, if you find people that you trust and you're like, well, I trust this person and, I believe what they say. Again, you have to reassess. I'm not going to pick a particular party and say one party's lying, the other party's not, because I'm looking at court documents. That's what I'm saying. There have been so many lies, in fact, 34, where Mr. Trump has been found to have lied. I've got that. Now, there are other situations. There are situations where Nancy Pelosi has made a false statement before. It doesn't matter in that they're not telling the truth, and that one's been convicted of a crime, 34 crimes, and one has not, right? So you might be like, well, one's more trustworthy than the other. Fine. But if you're not under oath, you just don't know if they're telling the truth, is what I'm trying to say here. I'm not trying to throw Nancy Pelosi under the bus. I think I have a lot of respect for Ms. Pelosi, but again, I mean, everybody has a moment when something they're saying isn't quite right. But when you're actually doing something illegal by not being truthful, that's a problem. And that's what this administration's doing. We have an administration of people not telling the truth in an illegal way. Right? So if I go to lunch and I'm like, I really had a great time at the movie, and that's a lie, so what? But if I go in front of the entire world and I say, like, I've taken care of all of the issues that we need to take care of so that, the world doesn't explode, and you haven't, like, that's not right. All right? That's kind of what I'm trying to say here. Long videos. Yes, and I've got a lot of them over there on my tube of view. When I say government, I'm glad you asked me that question. When I say government, I mean anyone working in the executive branch that was brought in with this president, anyone in Congress who is elected or works for someone who's elected, anyone in the Supreme Court. I cannot say the same for federal courts, and I just won't. But for the Supreme Court, when they're out doing their interviews and their book tours, again, if they're not under oath, I'm not going to believe what they're saying. But once they get into their courtroom, now I'm going to believe what they're saying. So that's what I mean by government. If you've been working in a government, for a few years, or even if you're a probationary employee and you are part of the support that makes it possible for our government to work, I'm probably going to believe you like I would any other person. But if you are in one of the three branches doing what you're doing, then yeah, we're going to have an issue. Even under oath, they lie. Yes, and that's the thing, is you can take an oath to uphold the Constitution, but also be a liar. And what happens then, because nowhere in the Constitution does it say you can't lie. It doesn't say that anywhere in there, right? That's why ICE will come out and be like, oh, we're just investigating something going on in your neighborhood. We're not, we're not even ICE. We're just regular police and blah, blah, blah. They can lie all they want because that's okay. But what they can't do is make a law or do something that blatantly violates the Constitution. That's what the oath is. The oath is just this blanket protection where you're not supposed to be acting in a way that would violate the Constitution. Right? Just to kind of clear that up. Tish James criminal referral. I haven't seen that. K-Dub has which criminal referral? She's referring criminals all the time. So, I mean, you'll have to be more specific. I mean, she is the AG over there, so she does that a lot. They lie to your face. Oh, yeah. Yeah. Working in their official capacity, they have to uphold their oath. Right. But on the other hand, when you think about it, there has to be some kind of accountability, right? If her mortgage fraud case. So, yeah, who's the defendant? Who's the defendant she's going after? Mind an adult not to lie. I know, Heidi, right? Can the military refuse to listen to Trump orders? That's a way complicated question. If something is a blatant violation of the Constitution and you are aware of that, and it's an order coming down, like your oath is to the Constitution, not to a person. Yeah, political speech has been stretched quite a bit. And you can have your First Amendment covered. I mean, lying is part of your First Amendment right, of course. Absolutely, Eddie. And I think they already are. I think they set things in place during the first term and are now solidifying that. What do you say about DV? I would say DV doesn't matter. That's irrelevant. Any criminal charges that are not filed are irrelevant. Just like when everyone said, well, you can indict a ham sandwich when Mr. Trump was indicted multiple times by grand juries. You can indict a ham sandwich. Well, there wasn't even an indictment for a DV. So, we don't even have a ham sandwich. We've got like a piece of bread. And we're not even sure if it's bread or not. So it's irrelevant to me. They lie in a deposition. That's perjury. Now you can go to prison up to 5 years. That would be perjury. I agree. Low frequencies, we're definitely going to have that situation. Yeah, I mean, it doesn't matter if she wants him home or doesn't want him home or loves him or hates him. It's not about her. It's about due process and the lack of it. Yeah, and then indict ham sandwich, exactly. Or, show me some proof that this is actually bread because you don't have any. Yeah, I mean, to lie in the regular. That's the one thing is that a lot of people, and I don't know if it's part of our culture or our American propaganda or what, where people are like, oh, everyone's so honest and, telling a lie is bad and blah, blah, blah. I'm like, seriously? Like, do you really think that? And maybe it's because I'm jaded, because I'm in the legal system. But if you don't have your hand raised and you're not promising to tell the truth, I doubt you're telling the truth. Yeah. I mean, it is. The whole situation's heartbreaking. But again, if I don't have any criminal charges, there's nothing to support that. There's nothing to support anything. Yeah. Right, exactly, Jim. Legality and morality have always been fighting each other since, the beginning of language. since language. Yeah, I mean, again, we don't have any information. Anything written into affidavits or filed, like a police report or whatever, we don't have any way to determine the credibility of that. And police reports are not allowed as evidence because they're seen as you can't bring them into court. You cannot have a police officer read his report or her report. And there's a reason for that. So if you're looking at police reports and various other things, like that's just not admissible evidence. Will you write a book about your closet docket one day? Oh my gosh, I don't know. I might, everybody. I am trying to figure out how to get my shorts over on YouTube to be in a way that I can do my closet docket updates and everybody knows what day I'm talking about. That's the only problem with that. But maybe he gets a judgment. How do they enforce his return? Well, there's nothing that's been filed. There's no judgment on anything. So that's just not in the equation. Can FOIA be used to find out what is in the contract with El Salvador? Great question. You can file a FOIA for a federal agency, I guess. I would say a federal level in order to ask for certain information. I'm not sure that, the Department of Homeland Security, you could say I'm requesting information on the contract that you have with El Salvador, and they will probably say that it's classified. So you can certainly ask, but if they're not even willing to tell a judge unclassified information that people saw on a video posted on social media, the FOIA person at the DHS is going to be like, nope, I'm not going to do that. Bondi in big trouble. The thing is, and what happens in these kinds of situations is that you ride the wave, the power wave, as much as you want. Like right now, it's like, I'm in charge. I'm the best thing, greatest thing ever. You can't touch me. Like you ride that wave, just like they all rode that wave for 2020. But then you crash. And you crash and burn. And that's exactly what happened to everyone that did the same thing in 2020. So at some point, there's going to be a crash and a burn. It's going to take some time, but that accountability will be there. It's possible people are going to go to jail. It depends on if they want to keep doubling down on their bologna sandwiches or if they want to actually use the brain that they have and be like, it's not worth it. This isn't worth it. Just comply with the court's order. And I'm not trying to say like, oh, you're submitting. No, it's just basic respect, basic manners to comply with a court order. It's just like, this government that's created, it's like we're in the government's house, even though we're the ones that built the house. You still are like, well, I want to make sure that my house still stands. That means you need to follow the court orders. So, be respectful about it. Right. Well, and that's the thing is that I'm not a person who submits at all. But what I do is I respect the laws that the system has put into place in order for us to have a country. All right. I respect that enough. Like I voted for people who wrote these laws and now these judges are implementing these laws. So, by not following a judge's order, it's like I'm going against myself, right? 1 to 10, how concerned should we be about this situation? So this whole El Salvador situation, I would say, and again, concerning, we don't know, but as far as historically, as one of the tragedies in our country, I would say we're definitely at an 8, creeping into a 9. And with still some higher levels to go, every time they file something, we get an inch further into an absolute tragedy in this country. States in a pleading, the apartment is an LLC. What? But there's no that I don't know. You're not supposed to put false information into filings. This is the tipping point. If he isn't brought back, this is our moment to mobilize. Perhaps, but I think we've been mobilizing. I think our mobilizing looks different than what a lot of people think, right? So a lot of people are like, oh, pitchforks, but in this day and age, the mobilizing, in my humble opinion, because I'm biased, is in the courts. Like, we are fighting a civil war right now in the courts. That's what we're fighting. So each lawsuit is another battle that we're going through, and we're winning some, we're losing some, and then at the very end, when we have our final set of precedents setting out how far the executive branch can just, smash through everything, that will be the end result. And that's how I view it. I don't see, again, pitchforks and Beauty and the Beast style, go get the beast. It's more of this is now the doctrine. These are the guardrails. This is now what we have to make sure everybody follows. And it could go, a couple different ways. And so I'm not really sure how that's going to come down. You're welcome, Paul. You betcha. It's free of charge. The courts will hold. I believe so too. This is the beginning. Lots of lawsuits. Oh yeah. I mean, we're over. We might have hit 200. I will have to check that. It's going to get ugly. Absolutely. It's going to absolutely. What happens if he doesn't listen? We don't know. We don't know at this point. Like anything's on the table. I would say right now you can't eliminate any option. All options are on the table. Are the people that are keeping me sane? Oh, Katie, I know. We're going through it right now, everybody. We're absolutely going through it. And it's a very difficult time. And I will confess right now that my hubs came up the other day and he said, "Do you realize that you are screaming more than normal?" I said, "What?" And so my family apparently had an intervention with me. And they're like, "You just walk around and whatever you're doing, you just randomly scream." And I said, "Really? I don't know." I said, my husband's like, "I think it's the stress." And so I have this little sign now in all of the places in my house, like, "Don't scream." Oh my gosh. I know, right? When you're confronted by your family and they're like, "You're screaming more than usual." And it's true. It's true. I'll just walk outside to get the mail and I just am like screaming. And I'm like, what was I doing? Okay. It happens. It happens, Right. So I know a lot of people are worried about martial law. Here's the trick to it, all right? Martial law can be requested by governors. Because we have a federalism system, martial law of having the entire military shut the entire country down, that is not a thing. That is not a thing. We had military go in Little Rock, Arkansas, in order to protect children after desegregation. All right. So that's an example of when that power was used by the president to override a governor's, law, because the governor didn't want to desegregate and the Supreme Court said you had to. That's an example of martial law, what that looks like in this country. So we don't have, everything slammed down and everyone's walking through the streets with, giant, whatevers. That's not how our martial law works over here, because we have a weird, unique government because of federalism. Now, it could lock down DC because Trump has the authority basically of a governor over DC. But when it comes to the other states, it's a little bit different. Yes, it's a little bit different. I'm not saying it's good or that it's okay or not to worry. I'm just saying it's different than what most people are thinking about with tanks going through everywhere. Our system works differently than that. And primarily it's because the governors of our states have the ability to kind of set things into place. Silence rogue courts, they've been trying to do that since before we even had a constitution. That's been going on for quite a while. Yeah. And judge-made law or activist judges, I mean, they've been saying that since, I think, John Marshall, right? He was, I think, maybe the second or third Chief Justice, maybe the second after John Jay. But John Jay was seen, even the very first U.S. Supreme Court Chief Justice, like, oh, he's an activist judge. because he wrote multiple Federalist Papers. It's kind of always been part of our culture to be like, oh, the judges are out of line. And that's one of the ways that we check our judiciary, is by saying, we're watching you. And if you get out of line, we're going to yell about it. And so bring yourself back in. I don't know. I wouldn't say we have rogue courts. We do have judges who can be incompetent, who are incompetent, who should not be judges. I do believe that is a thing. That's absolutely a thing, that they should not be at the bench because they're at a point where they are doing so much harm due to their own incompetence. Law firms are caving. Yeah, but the thing is, behind the scenes, everybody, just to put this out there, like the law firms that are caving, man, they're getting a lot of crap, and they should. They're getting a huge backlash from, attorneys, because this is an adversarial system. We fight people. And so to just like lay down before you even put the fight in, then that means you're just here for the money. You're not here for the fight. And when that happens, you have this break in the legal system between those of us that are fighting the good fight for the Constitution and those that are like, well, I've got 5 generations of Vanderbilts, and, we are very rich, and so I have to be an attorney. Like, there is a split in the legal community between those two roads of attorneys. So that's definitely at play right now. So when you're seeing firms that are like, we're going to take this all the way, those are the fighters. Those are the ones that woke up and said, I'm here to protect the Constitution. Meanwhile, the other ones are like, my dad got me into Harvard or wherever. Kind of to just give you a bit of an example, okay? If money is your driving force, then your morality is going to look different than if it's not. Kilmer's 2019 judgment, I didn't understand it. Yeah, I mean, what about it? So he came into the country, he was 17, about there, or 18. He was fleeing his country, right? And hung out and did not go and get his asylum paperwork filed, for whatever reason. You need to do it within a year. And so, when he was 19, I guess, his window expired. So he was found to be not documented properly. So he had raised this issue and said, hey, if you send me back, really, really awful things are going to happen. And there is a treaty with the UN under CAT, which is has to do with not sending someone to a place where they're going to be, physically harmed in a particular way. And so the judge said, he requested basically a deferment of deportation. So he would be protected and he wouldn't be shipped back to El Salvador because the evidence showed he would be in a bad situation that would violate the CAT of the UN that the US is a part of. So the judge was like, you meet the factors, so we're going to defer any kind of deportation. And then after that, he went in and checked. He had a case manager and went in and filed all of the information he needed, where he was, where he worked, met with them, make sure there's no criminal activity going on and various things. He did that for 5 years. And then, then he got picked up and sent to El Salvador. So that's the 2019 situation. The ballpark figure is hard to put a number into. That's a really hard to put a number into. Do you know why he was denied asylum? Because he missed the deadline. The statute of limitations ran. Right? So, and I think this is so important. He came to the country when he was basically 17. He had 1 year to file paperwork to start the process for asylum. He did not. All right? So this 8-year-old kid, I'm not trying to say he's not a bad person or whatever. I'm just giving you numbers, all right? Did not go and file asylum paperwork. The statute ran. You have 1 year. If you don't get your paperwork filed, the statute runs. And that's what happened. That's why he was denied asylum, because the statute of limitations ran. That's what happened there. Right. So the deferment of deportation was specific to El Salvador and actually to remove him from U.S. custody. But it's weird because in the order, I think the judge made a mistake a couple times because he kept referring to Guatemala. So at the very least, not to El Salvador, but a deportation was on the table, and they said we're not going to deport. You are going under the statute itself. Let me just show you real quick. Like I'm gonna come in here and I'm gonna be like blah 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 blah, and it's not gonna make any sense. Let me just show you the statute real quick, okay? Under the statute itself, you can apply for this kind of deferment here, which is what I'm talking about. And so it's all about the statutes. Okay, here we go. This is the statute. This is the law that you can use when you are part of a group that's being persecuted. You have a lot of different things you have to meet, a lot of requirements. He met them. He was part of a group that was being targeted. So he request, it's called withholding of removal under section 241B3B of the Act, all right? This has to do with the CAT Act, right, under the UN. So here we can withhold removal and withholding removal under the CAT Act is possible. So that's what he filed under. That's what the judge found him to have the issue with. So he was allowed then to have a withholding of removal. Now, it doesn't say withholding of removal for a specific country. You see what I'm saying? So that's why the answer is kind of different, because it's just saying a withholding of removal from the United States. We've got consideration of the application, eligibility for withholding of removal here, past threats here, future threat, reasonableness of internal relocation, which he went through and explained, eligibility for withholding of removal under CAT here, and mandatory denials are set out here, so it's not an automatic, it's not a given, and then there are exceptions. Removal to third country. Nothing in this section shall prevent the service from removing an alien to a third country other than the country to which removal has been withheld or deferred. So this is the only piece that speaks of if you're going to pull them completely out of the U.S. As part of a removal. And this is one of the biggest issues in a lawsuit, a class action that has been filed by some Venezuelans who are like, why are you sending everybody to El Salvador? They have filed a class action lawsuit because of this very issue. All right. No, there's no proof. We don't have any proof because we don't have any due process. Without due process, we have no rules of evidence. Without any rules of evidence, we have no proof. Yeah. Yep. Yeah, I know there's somebody saying, well, fine, we'll ship him over to wherever. It's like, well, yeah. But the thing is, being deported is not a prison sentence, right? So if you take somebody out of a country and put them in another country and off they go in the other country. But if someone's convicted of a crime, of a criminal crime, then you go to prison, right? So, if they're going to deport somebody or revoke the withholding of removal, then take them to another country. That does not mean you go to another country and you're put in prison. Like, what are you put in prison for? Isn't prison like for crimes? There's been no conviction, right? Where's the conviction of a crime that would say you need to be in prison? There's none. So if, they're like, oh, well, maybe he can be moved to Yemen or wherever. It's like, yeah, that's fine. Take him to Yemen. Let him go and live his life. Why is he in a prison in the country that he was protected from having to be sent back to because of the cats? All right. So that's the thing. That's the thing. fine. If he's not allowed in the United States, fine. At this point, that's a different battle. That's a different battle. The problem is he's, in a prison in the country where he shouldn't be. Now, if they want to pull him back into custody, give him due process, and then do some deportations, right? Due process means the order that's in place, they would have to be like, we're revoking the order. No one has revoked the order that has any power. No court has come in and revoked his withholding, right? That step's been skipped. But if they bring him back and they go through and they're like, well, we're revoking, there you go. I mean, you can send him somewhere else then. You can't send him to El Salvador, but somewhere else. But we don't have this order revoked. So this is a violation of not only this court's order, but the 2019 court's order as well. Well, again, I don't know what understandings there are and what, citizenship or whatever is at play. What I do know is he's protected under this specific piece of our federal code that says he can't go to El Salvador. Yes, contempt, for sure. Yeah, I mean, I think it's important that we recognize, again, where's the crime, right? Where's the crime? Where he is justifiably put into prison. So it's a lot. It's pretty atrocious. This is historically, one of the worst things our country has done when it comes to basic human rights. We've got a lot of problems going on here. Yeah, they've not been charged with crimes. Exactly. And, reading through the complaints that have been filed in the lawsuits involving this, they're like, dude, I mean, what? If you are wanting them out of the U.S., then go through the proper immigration channels, which is another issue that's been going on here. You removed him under a statute that should not have been used and put him in a situation that violates the court order that was protecting him. He wasn't, I mean, I don't care. If this had been Biden, if Biden had even withdrawn this and been like, well, he's out, and shipped him without having a proper court order, it'd be like, this is a problem, Biden. Don't screw this up. You just screwed this up. I don't care who it is. It's a court order, and the only way to not follow a court order is if another court rescinds the order, and we don't have that here. We don't have it. Yeah, I get it. There's just so much of that hypocritical stuff going on here. Right. Could the court say Trump can't deport anyone else without proof of due process? Kim, that's exactly what the Supreme Court said. That's what the Supreme Court said in their decision. Now, I know the administration's like, yay, we won the court decision. No, what happened in that decision was the U.S. Supreme Court unanimously said that during deportation processes, non-citizens have a right to due process and have a right to habeas corpus and the opportunity to exercise that right. That is precedent now solidified by the U.S. Supreme Court from the decision in this case. That's exactly what happened. Oh, I know. The oopsie is really bad. Anyone, that's right. Anyone, unanimously, anybody. You are non-citizens, it's fine. Even if you're in the process of being deported, it's fine. But you have a right to habeas. They are trying peanut butter. That sounds tasty. We've got half a dozen lawsuits going right now. I should do another closet docket post, everybody. We've got habeas corpus cases left and right, just flooding right now. We have classes that are being defined. There was a class just defined in New York, class action regarding this issue. We've got habeas being filed. We actually have a habeas hearing being set for May for someone who said, I'm not part of this bad group. So a hearing, an evidentiary hearing's been set so that the government can come in and show the proof that they have. That's going on too. So these cases are absolutely rolling in for the people that were taken there under the Alien Enemies Act, the people that were taken there under other immigration reasons, the people individually who are accused of being part of this group are filing habeas suits too. So we got the suits. We got the suits going. We got a lot of suits. Are you going to keep doing lives? Okay. So yeah, let me close up here by saying to everybody, I'm over on the Tube of You, and it's the same handle. I'm over there. I'm doing lives Tuesdays, Thursdays, and Sundays. Although right now, because there's so much going on with this case, I've been back over here on the Talk. But if the Talk, is rumored, it may be going down sooner rather than later, I will be doing lives, probably daily lives, going through the filings for these cases. And I will be doing them over on the Tube. So subscribe over there. It's free to subscribe unless you want to be like a member. The language is different over there. But go over there, hit the button thing, and then that way you'll know when I'm live. I'm typically going live at 7 o'clock Central PM to go through paperwork. But once the once things start getting a bit dicey, so basically after Sunday, I'll be going multiple times a day live as well, as long as my voice holds out. So follow me over there, everyone, and your favorite creators, just so that you don't get lost, because I do this exact same thing, only it's over on the Tube. We've got the moderators, we've got the chat going, I've got the nails, everything's the same. It's over there. And I can say a lot of the words that I can't say over here. So go over there and click the button and make sure that you, if you want to follow this case, I'm following both of these El Salvador cases very closely. And then, of course, I do a lot of other lives as well. But this is the big one right now, and rightfully so. So come catch me over there. Come catch me over there for sure. Right. Rumor has it that the Talk's going down on Sunday. And I believe that. I do believe that. I trust my source. It's possible I could be wrong. Who knows anymore? But I'm proceeding as though it's going down on Sunday. So I'm kind of doing these constant updates over here on the Talk, but getting ready for everything to be moved over permanently to YouTube. And I've already got my shorts up there, my shorts, my YouTube short videos, and then I've got my longer ones. So I've been working on getting that all set up for, I don't know, maybe 6 months now. So we're good to go. Everything is up and running over there. So if it does go dark on Sunday, then we're good to go. But we really, a lot of people thought we had till June, but it's sounding like the app is just like, we're done. We're done. And I think it's because of the tariff situation. I think they're just like, we're done. Yeah, the extension, but there's no further discussion about selling. There's no further option. So they're kind of just like, well, we're done. We're just done. I know. That's what the word on the street is. And that is coming from a pretty reliable source. Now, I could be wrong. It would be great if I was wrong. But I'm proceeding as though that's exactly what's going to happen. So that's how I'm working towards that. Yeah, exactly. Oh, I know. Something else. I know. China stops negotiations. Yeah, China had already said, look, the algorithm, good frickin' luck. We're not getting rid of it. So we kind of already knew that was in the mix. And the Supreme Court approved the congressional law, which I disagree with. I think we have a First Amendment issue, huge, but the Supreme Court, said what they said. So here we go. This is why we're in a bit of a mess. Yes, go record. Somebody was saying, do a video of your follow list or screenshots or whatever, just to make sure that you've got the information of the people you're following. So you don't want to lose your connections with the communities that you've been building and the information that you've been gathering. You just don't want to lose that. And I know creators are moving to other places. Some are on Substack, some are on the Blue Sky, which I'm on the Blue Sky. Now that the Skylight's up and running, I've been posting over there too. So that's kind of like my shorts, or like my daily posts for TikTok are going up over there as well. And a lot of people are moving over to the tube. Yeah, Lemon 8 will go down. Yeah, I'm not a big fan of Meta, but I do keep the door open just to make sure if anything happens that I do have a place where people can go. So I am on Insta. I mean, I don't really have a Facebook. My Facebook is just like, I've got a couple family members. So that's the only reason why I have that up and running. But yeah, Blue Sky. Yep. Whack-a-mole. Oh, I know. That's a really good way of putting it. But with that, my friends, I will go ahead and sign off for today. I will not be able to be live tonight. I am planning to rest my voice as much as I can so that I'm ready in case another order just comes out. So, thank you so much. Thank you so much. But I would say I'm just following court documents, everyone. I am not coming on and based off of any news reporting or any other creators posts. I am only going into and looking through the court documents, the exhibits, and various other things. So that's the only place where I'm getting the knowledge that I'm sharing. If you want extra commentary or extra insight, go for it. Absolutely go for it. But for me, I'm just focusing on the court paperworks and orders. So thank you so much for coming. And to my moderators, as always, I appreciate you so very, very much. Have a good rest of your day, everybody. And again, if there's a new order that comes out, I will pop on to explain it. And I need to put together that ethics video. So I'll be working on that today. Take care, everybody, and have a great rest of your day.